one more angle from which, my lord, your lordships can consider the question whether bribery can at all be protected by the immunity or the privilege. Because, my lord, neither the majority nor the minority in Narasimha Rao, Lord, examines the issue from this point of view. If it is complete outside the house, then, well, your lordships need not be bothered by us as to whether they would be protected, immunity would stand extended, privilege would be granted, etc. Please see, my lord.
Actually, the place, Mr. Solicitor, the place where it is completed, or whether it is antecedent or subsequent to the speech or vote, really should not matter in that sense, because then it will be a fortuitous circumstance. So suppose we'll just give you a hypothetical example. Suppose the agreement to pay a bribe is arrived at within the house itself, may not be beyond the realm of possibility. That then agreement to pay the bribe is the offer and the acceptance takes place within the house. Maybe when some third party is visiting the house for a committee meeting. We are just giving you hypothetical possibilities.
Correct.
That's the argument. It makes no difference. So it would not really, in that sense, it should make no difference to the final argument or the legal position in that sense.
No, there is a reason why, my lord, I would...
of course, bribery, you're right. This is on a very, very strong footing that, well, the offense of bribery is complete outside the house, you say.
Yes, my lord. But there is a reason why I am reading the provisions of Section 7 which existed when Narasimha Rao judgment was decided. The reason is, in 2018, Section 7 came to be amended. The argument in Narasimha Rao is that the performance of the promise for which you took the money would be a relevant guiding principle.
Right.
Whether you voted in favor, whether you voted against it, etc., etc. Lord, if that is the logic, which according to me is a flawed logic, then that gets further, my lord, substantiated. My submission is substantiated by the amended provision, but before that I may show the...
No, fair enough. I now got it. Let's see para 5 onwards. We can first read your formulation and then you can maybe explain it to us.
Please, your lordship. Lord, the legislature, while formulating Section 7, was conscious, or at least presumed to be conscious, of the provisions contained in Section 105 and 194.
Yes.
And therefore, specifically makes reference to Parliament or Legislative Assembly while defining and providing for the punishment for bribery. Lord, perhaps it can be said to be a little far-fetched, but Lord, is it not, Lord, I'm posing a question to myself, a manifestation of Article 194.3? 194.3 says that the Parliament can legislate as to what would be excluded from the immunities or privileges. So by incorporating Parliament and legislature in the definition of the Prevention of Corruption Act itself.
Yes.
Now, second ingredient, which is quite startling. Your lordships are aware, but at more than one places the majority in PV Narasimha Rao case holds that everything would depend what you do out after you go inside the Hall of Parliament or within the Parliament, whether you vote, you do not vote, you vote as per the promise given, etc. But here, performance of that motive or reward for which you were paid bribe is not an ingredient at all. The moment I accept or agrees to accept or attempts to accept or obtain, the crime is complete. So performance, my lord, which is an underlying ratio in the senior, in majority view in PV Narasimha Rao case, is absent.
Yes.
Lord, similarly, at page 4, Lord, I have placed for your lordship's consideration section 13 as it existed there. Again, performance, what you do, is irrelevant. Your lordships are right, Lord, in many cases, it is quite possible that the agreement takes place within the house. Lord, in extraordinary cases, even the acceptance of money also can take place inside the house. But your lordships would not, my lord, interpret the provision based upon
the place at which the bribe is given.
Yes, and my lord, some extraordinary circumstances. Suppose one MP hands over a bag containing 2 crores to another MP inside the hall, that you vote up in a particular way. Quite possible, but it is one out of 1,000 possibility. Generally, we go by, my lord, the Prevention of Corruption Act, the way in which bribery takes place. So your lordship's interpretation may perhaps not be guided, not by extreme examples. Suppose he goes inside and discharges his duties properly, but he accepts the money. But my respectful submission is that the connection essentially, my lord, established in majority view of Narasimha Rao as to how you perform your part of the bargain is irrelevant for the offense of bribery.
The majority does not specifically dwell on this at all.
It does not refer to at all.
Actually, it was the minority. Justice Agarwal says that, well, the offense of bribery is complete the moment that there is an agreement.
So that's not the correct view. But this is completely, what happens is, the majority says...
did not deal with it at all.
At all.
Or did the majority say that unless there is performance, there is no bribery? They don't say to the contrary also.
Not so.
Yeah, yes, but when they say that unless there is performance, there is no bribery,
right. That's how they, all right.
May perhaps run contrary to the act itself. That's the respect. I'm just taking your lordships through what we could find out to assist your lordships. I'm not reading it, because now the way, in which even the petitioners have argued, this may not have any direct relationship, because it's nobody's case that there need not be a privilege or immunity. Everyone says that there has to be. The only question is whether bribery can ever be protected under the privilege or immunity. Then page 21, need for the privilege. Your lordships are aware, to ensure that I vote, I exercise my rights and perform my duties freely and fearlessly. That's, in one line, the object of the privilege. Then your lordships may directly come to the position in India at page 24 at the foot. I am not reading it, my lord. We have gathered, my lord, various provisions, and my lord, for example, page 26, Government of India Act 1935 had similar provision for immunity and privileges. My lord, that was section 28 of the Government of India Act. Substantially, my lord, that is adopted in the Constitution. But I am not reading it, my lord. Then your lordships may kindly come to page 29, case law on privilege. But whatever judgments are delivered so far, to our knowledge, there may be few which we may have missed, are quoted, relevant provision is quoted. If your lordships would like to go through them. Then, page 33 is position across the world. We have try and call out, the position across the world. Again, my lord, for this limited questions which your lordships are examining, my lord, this may perhaps not be relevant except for some academic interest. Then, my lord, 37 is Chater. My lord, this is the judgment, my lord, I would respectfully rely upon. But, my lord, I'm told this is also, my lord, read before your lordships. Do I read it, my lord, or I may not trouble your lordships? But I think I should not trouble your lordships.
Which one were you saying, Mr.?
My lord, page 37.
37.
R versus Chater.
Chater, I think we have looked at, yes.
The lordships have, my lord, seen that. So I have just quoted the relevant paragraphs for ready reference. But I don't think, my lord, but my lord, at the foot of page 39, there is one paragraph 246. Now, this is the concurring view in Chater.
Yes.
But this, my lord, as a proposition of law, would be very, very relevant, because self-regulation is essential ingredient of separation of powers. All the three. Basically, your lordships are aware, parliamentary privilege is essentially against the crown, against the executive. But the law which has developed or evolved is that all three organs of the state would have the right and power of exclusive self-regulation without any interference by the other. In other words, my lord, the independence of self-regulatory power of parliament is as sacrosanct as, my lord, independence of judiciary or independence of executive. So that's the, my lord, judgment on this. Then, my lord, page 46, examples of exercise of power by parliament itself. Now, this may be of some interest to your lordships. Of course, this may not assist your lordships in arriving at any conclusion on the question on hand. But whatever examples we could find out in India, that how this power of self-regulation is utilized by our parliament. So those examples are cited, right from my lord Mudgal case. So my lord, this is my respectful submission, my lord, that bribery can never be a subject matter of immunity. Unless, of course, my lord, 1 out of 1,000 cases, my lord, takes place within the house. But my lord, this is not examined. This angle is not examined either by majority or minority. So, my lord, this is, my lord, just for your lordship's kind consideration. Instead of, my lord, declaring Narasimha Rao to be not a good law, the lordships may have an option of saying that it is per incurium, because it does not take into account the statutory scheme of the prevention of corruption.
Yes.
And performance is irrelevant. And the offense, which encompasses all its ingredients, does not include performance. And when everything is outside the house and the offense is complete outside the house, there is no question of privilege being claimed or immunity being established as a defense. So these are my respectful submissions.
Thank you, Mr. Solicitor. Thank you.
My apologies, my lord, and grateful my lords permitted me to virtually.
Thank you, Mr. Solicitor.